Good evening, everybody. Goeienaand. Mweni. Welcome here in Stellenbosch at the Faculty of Law. My name is Nicholas Smith. I'm the Dean of the Faculty. And thank you, Professor Kajika Sadula, for giving me the opportunity to open and welcome everybody here tonight. This is the 2023 Annual IP Public Lecture presented by the Anton Mostert Chair in Intellectual Property Law. And please allow me to extend a special word of welcome to just a few people. First of all, Professor Daresh Ramjuganath, he's our Deputy Vice Chancellor, Learning and Teaching. Professor Andreas van Wyk, former SU Rector and Dean of this Faculty of Law. Remgro staff in attendance tonight. And of course, a very warm welcome to Von Seidel staff, and in particular, Bastian Koster and Erik van der Vyver. As you know, Von Seidel's is our very generous sponsor of tonight's public lecture. Now, I'm sure that all of you will agree that it's a very busy October here in Stellenbosch. It's Woordfeest, it's Open Garden Week, we have alumni events this weekend. Very, very busy. However, above all, tonight is our final public lecture for this year, for the year of 2023. We also hosted an annual social justice summit at Artscape in Cape Town today, but this IP lecture formally concludes our program of public lectures for this year. So it really gives me pleasure to welcome all the practitioners, my colleagues, staff, students, and anybody who I haven't mentioned up to now as guests and for attending tonight. Now, it is said that knowledge is of no value unless you put it into practice, and that knowledge increases by sharing, but not by saving. And this, of course, is the philosophy behind public lectures as well. So we have prominent people, eminent experts in their respective fields, and therefore it's a very special honor for me to welcome Chris Jobs, who will be our speaker tonight and who will be presenting the topic, Gin and Tonic, anyone? And Chris, may I say, I really look forward to issuing that invite or question here from the podium. So thank you for your creativity with that subject. I want to say thank you all for your continuing support of our faculty. Our faculty prides itself in not only our alumni networks, being a special place for people, an intellectual home, but also being rooted and involved with practice. So it's really indeed a special honor for me to also ask Bastian whether he will come up. It's now his honor to introduce our speaker, Chris, to all of you. Thank you very much.
Thank you. Thank you, Prof, and good evening, everybody. I have known Chris since 1988, so I think I'm the person in the room who has known you for the longest. Now, it's always dangerous to the speaker if you ask somebody with my personality to introduce somebody with your reputation. It might be time for revenge. I'm not going to go through his bio. His bio was on the program. It's really a broad outline. But I thought it might be appropriate to introduce Chris by drawing an analogy between him and Clint Eastwood. He says good. and the movie The Good, the Bad, and the Ugly. No, it's not all the same. So in Chris's case, it's actually the ugly, the bad, and the good. And I will explain the ugly. Now, I met Chris in '88 when I started at the firm John & Tonic. And within a week or two, I found myself in a lecture room where Chris was lecturing trademark law to the first-year patent and trademark students. And I remember that first lecture very well. Chris, as you will hear tonight, is an excellent speaker and a lecturer, and he loves teaching. Now, it all went well, and he gave us some reading material, a couple of cases. Those who know Chris, he loves cases. Now, most of us, like myself, didn't read the cases, and 2 weeks later we will back to hear what Chris is going to tell us today. But the story changed. He asked questions, not to us, but to the immediate person on his left. And if you don't know the question, he didn't go on to the next person. He stayed with you because he could see you need some special attention. And that's where the ugly part started. Now, we then thought of actually not attending, but Chris was a major in the artillery after his military service, so he also took roll call. So it means if you don't come, it's a sudden death. If you come unprepared, it's a slow, painful, ugly death. So, well, we just had to go, and I last night looked for my results, and I passed your subject with flying colors. Thank you for that. Turning to the bad and the good, we have to go into his career, and there it's fairly simple. If he acts for you, it's good. If he acts against you, it's bad to ugly. But the good part doesn't stop there. So when I became a partner at John & Koenig, Chris moved to Adams, and I always wondered if me becoming a partner has something to do with it. I'll ask him later tonight. But at Adams he really excelled, and Chris has no doubt become the most formidable litigator in IP. And I remember when, after Chris left John & Koenig, we were talking one night amongst the partners, and it was Paul Novelli who said that. He said, you know, if you have a really, really important case, but it's, you know, the future of your business depends on it, who would you give it to? And I remember his words to the day. He said, you may not like him necessarily, but you'll give it to Chris. Turning to Clint Eastwood's career, he made cowboy movies, but he continued with a second career. And Chris did the same after he retired from Adams & Adams. He continued. Very involved in education and training that he loves, and also playing a role in the IP profession. Clint Eastwood was 88 when he made the movie The Mule, and they asked him, how do you do it? He said, well, you get up every morning and you get out and you keep the old man out. No, Chris, you certainly keep the old man out. And it's a beautiful song that was written by, I think it's Tony Keith, and one of the phrases is, how old would you be if you don't know the day of your birth? Clint Eastwood is now 93, and he's making another movie. The title is Juror 2, and it's about a murder trial where one of the jurors discovered during the trial that he, the juror, was actually responsible for the death of the victim. Now, Chris, I hope we're not going to discover tonight that you were responsible for the death of Gin and Tonic. Ladies and gentlemen, it gives me a great pleasure to bring to you the Clint Eastwood of IP litigation in South Africa. But just a few warnings: cock your guns, raise your level of awareness, because he might just ask some questions afterwards. Chris?
Bastian, I love you. Thank you so much for those wonderful words. And no, I didn't leave John & Koenig because of you. I left for other reasons, and I've missed you ever since, quite frankly. And I miss Mike van Seidel, who was my partner at that time as well. And congratulations to you and the firm that you've created. It's absolutely amazing, and all strength to you in the future. Everybody, it's so good to be here. I must extend special thanks to Prof. Kajika Sadula for the invitation to be here, to all members of the law faculty, to Prof. Nicholas Smith over the screen there, and to all and every one of you, to colleagues, to staff from Remgro, to our sponsor. It's wonderful to be here. What a wonderful university. How envious are so many of us of this university. How much do we hate this university from time to time? I've had the great privilege of working with many graduates from this university, from this law faculty. And they have, without exception, maybe one or two, been absolutely remarkable. They have been, they really have some special quality. They are very proud. They are very, the pride is the thing that kind of sticks in one's mind. They're very proud of this university and the fact that they spent time here. I'll give you one very, very good example, and her name is Kelly Thompson, who graduated here some years ago and currently is the chairperson of my old firm, Adams & Adams. And what an amazing lawyer she has become, and so many others from this institution. Talking about the Stellenbosch graduates who came into my orbit, I had a standard leg pull because I think they always thought, and I think they do think, they're a slight cut above. And you know, maybe you are, but doesn't go down well in Pretoria very much. And so I would, at my first discussion, if they were my candidate attorney, and I'd come and have a chat and tell me about yourself and where you're from and what varsity did you go to, and they'd say, Stellenbosch, and I'd say, where's that? and they'd think I was joking, and I'd keep a deadpan face and say, so where's that again? They get so upset. I've always said, and I know from what Bastian has said, you won't know this about me, but I believe very strongly in a sense of humor. I believe very strongly you can perform no task, certainly not litigate or act professionally or be an academic, unless you maintain a very, very strong sense of humor. And you've got to keep laughing and smiling despite the adverse winds that will blow in your direction, despite. All right, we are here to address the subject of brands in the form or in the representation that trademarks are to brands. Now, I need hardly say to anybody here what the value of a brand is. The brand value is just incredible. It does so much. It is of the value that brands possess are obviously monetary or financial in the first place. They have actual value as an incorporeal property right recognized by the Constitution and by the Constitutional Court. And so they have that value, but they have much stronger and other values. They are the attractive force, the force that makes you decide what to purchase. It is a guarantee to the public, and there is a whole bundle. And the very good thing is that the courts, including the CC and the SCA, have recognized these other values that brands, that trademarks possess, not just the origin function to indicate origin, but these added important values. And in fact, as long ago, if not prior anyway, in 1942, the US Supreme Court, in a very eloquent exposition, spoke about the value of the brands and how they are the psychological symbols that, in fact, is a shortcut in the marketing and merchandising field. And our Constitutional Court, Albie Sachs, in the Laugh It Off case, picked this up and actually quoted with approval. So I think we all know about that. But the point, actually, is that all very well and good have this wonderful, valuable brand, but unless the brand can be protected, unless the trademark can be adequately legally protected, it will lose all its value. The infringers, as many of you will know who litigate, the cunningness and the frequency of infringement of trademarks is never ending, thank heavens. I mean, one's in practice to try and make some money out of this thing. And the schemes get cleverer and cleverer, and the law must be alive to be able adequately and not excessively to protect those brands. And that is to protect the brand value, but to protect consumers against confusion and deception in the marketplace. And it is in this context that I want to discuss with you. This whole talk turns around the meaning of the word similar. It sounds so trivial, it sounds so boring, but do we all get ourselves in a terrible knot in trying to deal with this subject? And so I will now commence. Oh, I must thank you all very much. No, sorry, I think you must thank me. Got that quite wrong. For coming up with the subject this evening. Yes, and if I hadn't come up with it, you would not have had gins and tonic beforehand, and would not have had such a lot of fun before you even got into the room. So thank you, everybody. All right, similarity. It's encountered in trademark law in two related contexts. Where two trademarks are being compared, like Dairy Bell and Cowbell, this is an SCA case. The question is whether they are confusingly or deceptively similar. Many of you will know this. So one has to look at this to decide whether the similarity is sufficiently great that a consumer will pick up Cowbell, some dairy product, I forget what it was, rather than Dairy Bell. And after much back and forth, Judge Horrams was very clear that they were not confusingly similar. Now, I must emphasize that my talk this evening is in the context of trademarks that are not well known. Well-known trademarks get very special protection under the Act. I'm talking about good, everyday trademarks that might not be able to be proven to be well-known. It's a very difficult thing to do, very expensive if you want to prove your trademark is well-known. Do a market survey for over R1 million these days to try and prove this. It's hugely cost-heavy to do that. Now, I'm not talking about that this evening. I'm talking about trademarks that have value and might be distinctive trademarks, but not necessarily well-known. So, comparing two trademarks, is there sufficient similarity to hold that there's likelihood of confusion? And then the second leg is you've got to look at the goods or the services in respect of which the trademarks are either being registered or used. So is soap similar to shampoo? Yes, no. And sometimes your whole case can turn on this assessment. Now, obviously, there will be cases where the two trademarks are identical, so there's no debate. There'll be cases where the two sets of goods are identical. But I'm on the edge of the story where things are not quite the same, and you're trying to interdict what you believe to be an infringement of your rights. So the two concepts come together in two main ways. One is where somebody tries to register a trademark, and you apply to register, and somebody else with a prior right wants to oppose that trademark application. That's section 1014 of the Act. Or more importantly, and much often, I think, somebody is trying to use a trademark that is alleged to be an infringement, and you want to stop them. You want to stop the infringing use. And there you go to section 34.1 of the Act. So 34.1c deals with well-known trademarks, but I'm not addressing that this evening. Now, the way the courts go about trying to assess whether there is an infringement, first of all, they assess and compare the respective goods and services. So the earlier trademark will be registered, let's say, for certain goods. The later trademark is being used for certain goods. If they're identical, you're home and dry. If they're not, you need to determine whether they're sufficiently similar to lead to confusion. The next step is that you do the two trademarks and see if they are confusingly similar. And the third step is once you've got some sort of an answer or feeling for these two, I say you put them in a blender, press the button, and you do what the courts refer to as a global assessment, and you make a value judgment. And the thing about these value judgments is that this assessment, apart maybe from the goods comparison, particularly in trademarks, it's not an interpretation of a contract or a statute. It's not science. It's not maths. It's a very tricky business, and hence, particularly Judge Louis Harms has said very clearly that you make a value judgment. The judge must make a value judgment. And wow, have they made some amazing value, quote unquote, judgments. But that's the job to do. And once that decision is made, it's very difficult, except in very obvious cases, to say that they were wrong. Very hard to criticize them. This next reference should be New Media Publishing, I'm sorry. This one said that where you've got these two tests, the trademark similarity and the good similarity, and this balancing act that you've got to do, and this blending, you actually must look at it from this perspective, that if the trademarks are very close, the goods need not be so close, and vice versa. If the goods are very close, a bit more leeway on the differences or similarities between the trademarks. Now look, I mean, similar is such a straightforward word. Looking or being almost but not exactly the same. It's like somebody or something but not exactly the same. Alike in substance or essentials. And so, does this really warrant a public lecture, engaging your interest and your valuable time to try and work and puzzle through this thing? It seems such a simple exercise, as I've said, even trivial perhaps. Well, read it. It's not. It's a slippery eel beyond words to try and get to the bottom of this. And having spent many years in practice doing this, I promise you, it's uncertain, it's unpredictable, it's intriguing, it's frustrating, but you have to come up with an answer. And indeed, any judge sitting in judgment has to grapple with this. So when we're coming to the similarity between two trademarks, I mean, there are hundreds of High Court cases. There are many tens of SCA cases, appellate division cases, since the early, even the 1800s, dealing with the subject. The principles involved are pretty well established now, and our locus classicus is the Plaskon-Evans case from the 80s, which has been repeated by almost every court, every SCA decision since that time, right up to the present. It's always dragged up because it is a very good judgment. It sets the, and we go back because I'm not dealing with that subject here, but basically you take the two trademarks, you've got to assess them visually, you've got to assess them phonetically. Do they sound the same or similar? And is there a conceptual similarity between them? You've got to look at what the dominant feature is. You've got to bear in mind imperfect recollection of consumers. There's a whole lovely set of criteria that are set out in doing that assessment. And it's also equally difficult. As I've said, I'm looking at the similarity between goods or services in relation to trademarks that are not well known. And the whole point and principle here is to prevent consumer confusion and deception and to enable trademark proprietors to stop. So just a little short history of our statutory provisions dealing with this. Under the 1916 Act, if you have a registration and you oppose a later trademark application, the confusing similarity between the trademarks must be established, but the goods had to be the same, identical. So if you were registered for soap and the other person was for soap, you're okay. If it was for hair shampoo, you were not okay. Similarly, the infringement provisions, you could only stop an infringing use, or alleged infringing use, if that was for identical goods. That was very narrow. The scope of the protection you got was very narrow. 63 Act, particularly after an amendment in 1971, when service marks were introduced, did two very interesting things. First of all, in relation to opposing a later trademark application based on an earlier registration, the section 17.1 said nothing about any goods or services. In fact, it was silent. It just wanted to assess the two trademarks. Although the nature of the goods might have performed a factor in that overall global assessment and value judgment. It didn't require this as a matter of law. There was no gateway. But the infringement provisions were quite narrow as the 1916 position. It said the goods had to be identical. So I've got a registration for beer. Is the other side using for beer? If not, there's no case. Which was, again, very narrow. So the current Act did two very significant things. First of all, when it comes to the question of registering a trademark and opposing, in the registry trying to deal and opposing a later application, it provided that the goods have to be identical or so similar as to be likely to lead to deception or confusion. So the similarity broadens the scope under the opposition provisions. And Section 34(1)(b) of the present Act also broadened the scope by extending the protection to similar goods or services. So there's quite a significant change. Now, how have our courts looked at this? And there's a bunch of quite interesting cases here. Yeah, we have Fushini against Jan Coetzee, and Fushini had a trademark registration due south. And most of you might know or not know the classification system for trademarks. You've got to register in a class. And there are 34 goods classes, and you've got to choose your class and the goods in respect to which you intend to use the trademark. And your registration is the scope of the registration is determined by that specification of goods that you put on the form, the application form. Now, the Fushini's had registrations in Class 8 for cutlery and goods of that nature. These are not exhaustive specifications. These are just highlight ones. 11, it had covered cooking apparatus. Class 21, kitchen utensils. 28, it had games. And then 35, it had registered for retail services. Now, Jan Coetzee applied to register the virtually identical trademark, due south, but in different classes. In Class 16 for paper articles and printed matter. In Class 29 for foodstuffs, meat, farm store products, coffee, tea and bread, and so on in Class 30, and for education and training services in terms of that section. And what the court had to do, it had to take basically these two sets of goods in the different classes and try to work out whether anything was similar, sufficiently similar. Bear in mind the trademarks are identical, so the similarity didn't have to be that strong. But it had to work to this. And you go to the judgment, it's got the tables, Class 8 and 16, it compares all these things. And I'm obviously not going to bore you with the details. But the court, in approaching this question of similarity or not, made reference to the case that we all rely on all the time and quote it. Every judgment that comes out of our courts at any level these days refers to what we call the British Sugar case. The British Sugar case is the first one which clearly set down the criteria you must look at whether to come to conclusion about similarity of the goods. You must first of all look at their respective uses. What are they used for? What is, is there some relationship? Are they the same or similar? Who are the users? Who are the typical consumers of these goods? You would look at, obviously, at the physical nature. It's a very important step. You've got to look at the trade channels through which they get into the trade. You've got to ask whether they're often seen either next to each other or in close proximity, on the same shelf in supermarkets, and whether they are competitive products. And those are the criteria. And applying all of those, the court in Fushini held that, first of all, that had been submitted by the one side's counsel that there just had to be some similarity. Don't go overboard with this thing. So long as there's some similarity between them, it's fine. The court said no, that's too broad. But it then went to hold that foods and kitchen utensils, don't be confused by the hamburger, sorry, it's just foods and kitchen utensils were not similar to cooking apparatus. you might think obvious. This thing, you know, this was a very serious case. This was an appeal decision. The services of Coetzee, which were those education services, were not similar to Foschini's retail services. The goods of Coetzee, which were, let's go back there, his goods were paper articles, foodstuffs, coffee, and education and training services. The court held that these were not similar. And it placed a lot of emphasis in making this analysis on the classification system. All these classes were different. But the law subsequently, and in many cases, the classification system is not definitive of whether goods are similar or not. You could have an article in class 25, clothing, and in class 18 made of leather goods. It might be a handbag and a dress. They might still be held to be similar. So that was a very difficult case, and perhaps its outcome was fairly, I won't say obvious, but certainly I'd say correct. Now, I mentioned already, British Sugar has been referred to endlessly in all our cases, but there's another one, the Boston Scientific case in the Office for Harmonization in the Internal Market. That's the European Union, where you file a community trademark application in the Union. This is the office, this is the registry, and in this case of Boston Scientific, it said that if you want to assess the similarity of goods or services, all relevant features of the relationship must be taken into account. Not only uses, users, but you've got to look at any possible area or aspect which might render them similar. And it added the factor of being complementary, if the goods are complementary. So we're starting to work around to gin and tonic here because, you know, there's some complementarity. But we've got a long way to go before we get to gin and tonic. So, and the court held, and this is important, the goods are complementary if there's a close connection between them, in the sense that the one is indispensable or important without the other. Indispensable or important. So you can keep thinking gin and tonic. Then we had the Zonkersdrift, the Mettenheimer Zonkersdrift case. Goods and issue, wine grapes, on the one hand, and wine. Different classes, but after, again, the SCA had a good look at this, and it came to the conclusion that the goods were not similar. Now, all these cases also turn on the evidence. This is being a little simplistic here. You've got to look at the actual evidence to show trade channels, how these things are marketed, and this case had quite significant evidence to establish that the trade channels were very different. The users were different. Yes, grapes go into wine, but the users of these grapes were people who made wine. The users of wine are people who drink wine. So there are these kind of subtle differences that one... And I must also just say that this is not... this was a little bit of a surprise at the time when it came out. And I must confess immediately, my then firm, Adams, acted for the unsuccessful Zonkersdrift vineyards. So I must confess. Another case with a bit of a surprising result. We have the trademark Chantel. It's the identical trademark. The one is registered for cosmetics, and somebody is either in an opposition or infringement case. It makes no difference, of what was sensitively referred to as women's intimate apparel, which we see above there. And the question is, were these sufficiently similar? And applying the test that I've given, the users, the court, and referring to an earlier quite well-known case called the Danko case under the old Act, came to the conclusion that there was sufficient similarity between these goods. Yeah, Prof. Yeah. So you see the slippery eel. Carrying on, position, the law in the UK and the EU is exactly the same as ours, and exactly the same, and that's why British Sugar is relevant to us and so on. It was very well demonstrated in the case of Waterford Wedgwood versus Assembled Investment. Assembled Investment is based, guess where? Here in Stellenbosch. And that, if you can read it clearly, is the Waterford estate trying to register Waterford as I recall, it was a community trademark for wine. And Waterford and Wedgford, Waterford and Wedgford separate trademarks now merged together. Waterford Crystal, I mean, is world famous, famous manufacturer of glassware, including obviously wine glasses. So they said, but here we've got wine and here we've got a wine glass now, you know, surely, you know. Thing is, it went through 4 courts. Okay, the opposition by Waterford failed in the initial office, the harmonization officer, OHIM, in Europe. It then goes to the first Board of Appeal and Waterford succeeds, then goes to the EU Court of First Instance, it failed, then goes to the EU Court of Appeal and failed. Now, this is serious litigation, and it all turns on a simple thing. Are these goods sufficiently similar? Oh, obviously, again, based on the evidence and so on, but the complementarity thing from Boston Scientific, it was held that these are not sufficiently complementary. Yes, you drink wine out of a wine glass, but you can drink wine out of the bottle. I don't know, one sees enough people doing that. You can drink Coca-Cola out of a... You can drink brandy and Coke, as they do in Pretoria, out of a wine glass. So, bang, that went that way. And then Yuppie Chef, again a case that went against the owner of the trademark Yuppie Chef, and the goods, it turned on the goods because the trademarks were very similar. It was Yuppie Chef, Yuppie Goods, Yuppie Gadgets, and the Yuppie Chef was selling kitchen equipment. You know, those are just examples. They were selling that kind of espresso machine, whatever, stuff you use in the kitchen, electrical stuff. And what Yuppie Gadgets was doing was selling those very same goods. So here wasn't a case of goods versus goods, but here was goods versus a selling service, but selling the same stuff. So you'd think, hello, you know. Anyway, bang, you're dead. They failed in another very surprising judgment at the time. So what do we learn from these cases in practice? As I have said repeatedly now, you get unexpected and surprising results. I mean, legal certainty is so important in everything that we do, and you can get just flummoxed sometimes by the way these things come out. I repeat, obviously dependent on the evidence. But the initial reaction, as I think I've already expressed, is that my initial reaction was that the wine and the grapes and the wine in Zonkersdrift had a pretty close connection, and that I'd thought that would succeed and that you would be able to prevent and stop the one. And I've said not sour grapes on my part because my firm was involved in it unsuccessfully. I would have thought that cosmetics and lingerie are physically very different. There might be some trade channel, obviously the users are the same, but the uses are really. But it was all turned around, it's all about adornment and about the aesthetic side of these products. And that was the decision that was reached. So the real issue is whether goods or services are so connected or associated, rather than similar, as to be likely to cause confusion, consumer confusion. And I believe that our law should ensure a sufficiently broad approach to the subject, that you've got to take a commercial and practical view of the situation to see whether consumer confusion might occur despite the fact that the goods might not be as similar as say, in the grape and the wine case, the Zonkersdrift. And only the British sugar criteria are really somewhat technical and, in my opinion, too narrow. So, you know, I'm going to put it to you now. I'm going to ask you, and you've got to answer yes or no, and I don't take any non-answers. I need either yes or no. I want you to apply the tests. And there's going to be an exam after. Now do it, and you're all going to be asked to put up your hand. One, I'm going to ask you who thinks there is and who thinks there isn't. So are these goods similar or not? Hello? Okay, you got the trademarks are pretty close, right? But there's gin and tonic. Now I'm not going to do it at length. Run through the British sugar tests. What are the uses? Well, yeah. They're used to refresh oneself, let's say. But they don't have to be used together. I mean, you know, people can drink any one or the other, or other things. The users, typically pretty much the same. Okay. Look, hello, everybody, you know, let's go outside again. But the nature of the goods, yeah, somebody wisely said to me, I gave a mock oral the other day to a group of people, and they said, yeah, but they're both liquids. So they're very similar. I said, yeah, you know, petrol's a liquid, you know, I mean, it's... So are they both liquids? Are they complementary? Yes. Are they sufficiently connected that the one is indispensable without the other? Okay. Now, who says they are similar goods? Hands up. Hands up for not similar goods. Now you see the problem with going to court with these things, because any one of you could be that judge, and I've got about a 50-50 room here on the subject. Okay, this, maybe there's a slight alcoholic bent to these slides, but I mean, yeah, trademark's pretty similar. Whiskey and soda, same story. I'm not going to bore you. All right, very quick, and I'm not going to bore you. I just quickly want to tell you what other countries do and how they handle this. It shows a very wide spectrum of thresholds of where you're comparing the goods. You get situations where you don't have to have any similarity, and you have situations where you have to have identity. They have to be exactly the same. And really, this is something that I want to use because I'll come to it at the end. I feel something should be done. So this is a country which requires the identical goods. The registration must be for whatever it covers. The infringement has got to be absolutely within that specification. To be registered for soap, it's got to be soap. But the countries are not always the same. Sometimes they treat infringement that way, but they treat registration and opposition a different way. So it's quite interesting. There's quite a lot of confusion as far as I'm concerned. So Kenya, you've got to have identical goods. In Mozambique, you've got to have identical goods. And in Zambia. A lot of countries only require or require similar goods for doing this comparison. South Africa, we apply that both in the context of where you're trying to register or oppose a trademark and infringement. Lesotho for infringement only. Nigeria for both, for the same description of goods or services, which has been interpreted to mean similar. It doesn't mean identical. Namibia, only infringement, not opposition. The similar goods continue. Mozambique for infringement. UK, both registration and infringement. India, both registration and infringement. Singapore, both. Brazil, registration only. You have to have similar goods. And Australia also has a similar goods requirement for both, for registration and for infringement. Some countries have a thing called closely related. And these are Lesotho, which requires them to be closely related if you want to succeed in an opposition. Now, there's a registration situation, as does Namibia, as does Botswana. And this is a different test, and I'll come back to it. Tanzania and Australia in relation to where it deals with services. So we've gone from identical to similar to closely related, and then no restriction. Our country in between those years under the previous act, the 63 Act, in the USA and Canada, they don't make any reference to goods or services. They just take an overall assessment and make a decision. Obviously, the nature of the goods is important, but it's not a gateway. Again, Botswana doesn't require it for for infringement. There's no restriction in Brazil. The interesting thing about Brazil, I think it's section 189, I think there's a typo. I might have to reread it, but they've criminalized trademark infringement in Brazil. And I'm not talking about kind of goods here and then those criminal offenses. I think it's an excellent idea. It's exactly what we should lock up everybody. The point I'm making, where countries have no restrictions like the States and Canada, that doesn't mean that the whole thing just gets thrown open and can have any goods. It still remains an important consideration. But it is not a doorway, it's not a gateway to go into. You can, even if they are dissimilar, you can still have an overall, that global assessment depending on the trademarks. Now, the similarity requirement is absolutely appropriate. I'm not saying it's wrong. We've got to have it. It's a good one. It's just too narrow, in my opinion. In any event, we have international obligations, but both under the TRIPS agreement of the World Trade Organization and under the Paris Convention. We were required, particularly under the TRIPS agreement. But as I've said, it's difficult to apply, can lead to anomalous and unexpected results. Okay, let's do it again, you know, I mean, here we go. These are not similar goods. But eggs and bacon, come on. But they're not similar. But if you saw, let's say, Escort shoulder bacon and Escort eggs, you'd say, hey, you know, you've got a case. Bread and butter. Torch and batteries, you know. They're not similar. Any of these, they're not similar. They might be complementary, you might use them together, but they're not similar. So this is the lacuna, if you like. This is the hole in the system. But they are definitely closely related. And you see, bread and butter don't satisfy that Boston Scientific test of being indispensable and important. I mean, you can obviously eat bread without butter. You know, I mean, that's obvious. But they are closely related. I mean, they're just part of our everyday lives. You know, have a slice of bread and butter. And I'd say that prevention of consumer confusion calls for those types of situations to be addressed as well. And I simply propose a modest and pragmatic amendment to, these are the sections where the similarity thing comes in, but 1014 particularly and 34.1, just add closely related. So the section reads, in relation to goods and services which are similar or closely related. That's rocket science, right? It'll reduce the anomalies and uncertainty. It'll address the obvious link or relationship between these goods. There's this goods services gap. Our courts haven't yet accepted, and I didn't emphasize that when I was dealing with the case, that it didn't, the SCA has held open the question whether goods can ever be similar to services. So like the yuppie chef situation, where the one is selling the goods that are covered by the other. That question still remains open, but doing this, they're obviously closely related, and I'd say that would enable that kind of infringement to be prevented. I believe doing this will just get to the heart of the true issue, namely the deception or confusion question. And I doff my cap to you all and thank you very much for this opportunity.
Chris has agreed to take a few questions. So are there questions in the audience? Ralph?
Thanks very much. It was extremely interesting. To what extent do you think that some of the background factors, and I'm thinking particularly of the things that would normally be in the unlawful competition bucket, so the conduct of the parties, whether the act was actually calculated to take advantage of the reputation of the trademark owner or not, affects the court's decision? Because the court has to apply trademark law when it's looking at trademarks. But if it's obvious, because of the evidence, that one of the parties was the bad actor, if I can call it that, or was trying to take advantage of the reputation, do you think that has an effect?
I think it always does, not only in this context. I mean, intent.
That messes up trademark law in a way.
Yeah, it does in a way.
Cases not
But you've got the value judgment, and that value judgment enables a court to balance these often invisible things, these psychological background things, but certainly the courts frown very heavily on people who try to pass off or infringe trademark rights.
I mean, if I could use the Waterford case as an
Yeah.
example, I mean, we all know Waterford, it's up the
Yeah.
road, it's a well-known wine farm. They were obviously selling,
Yeah.
they intend to, you know,
I think if
fight on the reputation.
what you're asking, if Stellenbosch Waterford had the intention to try and cozy up,
Yes.
I think it might well have, you know, but it's a matter of evidence. I've emphasised that Zonkersdrift and the Chantel cases had slightly surprising results. But you've got to read the judgments, obviously, and one can understand the rationale. But nevertheless, there's still something that's not gelling here. And yes, the answer is yes, but it applies in every unlawful situation if somebody was having intent.
Miss Endeavour, one of my students, I'm glad she's here tonight.
Hi.
Nice seeing you too. I just wanted to ask you, regarding the value judgment that you find out, sir, I want to ask, in a practical sense, how does it look like? How does the court determine the value judgment? Is it the same as how a reasonable person would look at it, or it's just another way that an expert would look at that value judgment?
Not an expert. Not expert, it lies with the court. I've written a whole article on this, and I don't want to bore you, but sorry, let me get some optical instruments here that I can see. I wrote a thing called the value judgment conundrum, but to try to answer you, and I'm not trying to promote this now, I'm just saying I dealt with a question of trademark values, because what the courts are meant to be doing is assessing the trademark values in making the value judgment. I mean, what value? And I've said that trademarks, it's now widely accepted, are far more than only badges of origin. They have additional values, which I've mentioned, the advertising value, the communication, you know, those values. In understanding and considering the nature of trademarks, regard should be had to commercial realities and requirements. And I actually quoted that US. But I said it is obviously not being suggested because, sorry, the US Supreme Court said, spoke about the psychological function of symbols, psychological function. So I'm saying it's obviously not being suggested that judges placed in the position of making these evaluations should have or exercise the skills of a psychologist. Courts must be pragmatic. But I go on to say that they have some of that line of judgments. So do you remember the ones we had Yuppie Chef, we had Black Knight.
Yeah.
They were so dimensional. The judges clear. This is SCA. Had no sort of feel. It's a matter of feel and some sense of understanding of these factors in the life of a trademark and brands and so on. And so that value judgment it entirely depends, as I've said, on the values of the judge. And the values might not only moral values and big things, but just your scope of your how you've lived your life, your upbringing, a lot of factors like that. So that's what makes all this so difficult, is that there's no yardstick, there's no clear interpretive approach to coming up with the answer. I don't know if that answers you, but it's a tricky business. That's all I can say to you.
I have to say, from what you say, I don't think I'm satisfied, but I will take it.
No. Let's go on now. Come and chat afterwards. I'll try and give you a better answer. As a Groucho Marx said, you don't like my principles. You know. I've got some others.
There's a question at the back. Is it Christine? Yeah.
Yeah. Yeah.
Will your 25 registration for goods and clothing cover you for virtual clothing? If you're going to do it as a service being offered online, if you're going to Yachty Chef, the SCA?
Well, the SCA Christine, the SCA has entirely dodged the issue. It has previously held that they're not. Goods and services cannot be similar. As a matter of interest, I'm involved in a case now which will undoubtedly go to the SCA, where this will be one of the very important questions. But I don't know. And the courts have been very hesitant, conservative, appropriately perhaps, but I think unimaginative. I think if you think in my past, there was a shoe shop called Cuthbert's. I don't know if anybody remembers.
Yes,
Cuthbert's.
there's a Cuthbert's building in Cape Town.
Okay,
still.
now,
Yeah.
so the shop's called Cuthbert's, and now somebody's selling Cuthbert's shoes. You know, hello, surely they're not similar on the SCA assessment. I think they are similar, but they're certainly closely related. Okay.
Any other questions? No? Just for the benefit of the recording, Christine's question related to the use of trademarks now in metaverses and,
Yes.
and the like.
But it's all online, it's all out there, it's in the ether. And, you know, the principles are the same, they should remain the same, but you've got to boil it down to goods or services in terms of the trademarks. So, I mean, that is a service. If you're running an online service, that is a service. All right, well, thank you, everybody.
Thanks, Chris. All that remains. This is a little gift from us.
Oh, wow, okay.
The poster of the lecture.
Thank you. Very nice. Oh, that's lovely. Thank you.
And some wine.
Oh, kleine salsa, not Zonka's.
Not salt. We didn't want to rub salt into the wounds.
Thank you very much. Please. We're going.
No, that's fine.
Thank you. So, a lot of my stuff here.
Let me help you. Okay. Anton. Okay. Well, all that remains is for me to thank Chris. I'm sure that you will agree that this was an interesting and stimulating talk. It created an actual buzz when he had the examples up there. As before, we will make the lecture, a video recording of the lecture available in a week or two. So if you know of any friends or colleagues who wanted to attend but couldn't, please let them know so they can access the lecture. And I just want to thank those whose efforts make this public lecture possible. In no particular order, I must thank some of my colleagues at the faculty who have worked behind the scenes, and some like Kathy and Gerda, who I'm sure are still beavering away behind the scenes to make tonight a success. I'd like to thank the Dean and her office for again allocating the IP public lecture slot on the faculty's calendar. I'd like to thank Annette and Gretchen and Bradley Greenhalgh. Thank you for making the necessary arrangements and the treats that you've organized, and for marketing this event via social media. Thanks to our photographic and video teams. We are, of course, thankful to Von Seidels for their generous support for this evening and beyond. Thanks to them, we can again enjoy delicious food and refreshments, which you will get courtesy of our caterer, Dilly from Baking Squirrel. I must say there is, of course, a downside to Von Seidel's support. In them, in particular, in the persons of Eric and Bastian, Annette has found kindred spirits and perfect allies to gang up against me. Annette is, in her own words, onopvoedbaar at the best of times. She has an endless energy to think up new initiatives, which I do my level best to pour cold water over, and she gets very enthusiastic support from Von Seidels. So thanks. So, you know, then I look like a stick in the mud or a fuddy-duddy. And of course, the G&Ts as pre-drinks tonight is but the latest example of this. Chris, I have a sneaking suspicion that your talk will leave a lasting legacy on the IP public lecture by way of some sort of meta effect, that in the future GNTs will be closely associated with the IP annual lecture. Last and by no means least, I'd like to thank all of you for attending and making this event a success. I'd like you to join us for snacks and drinks, and please have a safe journey home. Thanks.